Welcome to our discussion on the federal court system. Please note the background of this Prezi is the geographic boundaries of United States Courts of Appeals and United States District Courts, which I will reference again in a moment. Article 3 of the Constitution created only one court, the Supreme Court, and left it to Congress to create any additional federal courts that the country might need. Please make a note of that. If you need to pause, rewind, and write that down, please do so. As we saw earlier in this unit, Congress responded with a series of laws that created inferior or lower courts in the form of federal district courts and federal appellate courts, or courts of appeals. In addition to these constitutionally and legislatively created courts, each state has its own independent state court system structured by state constitutions. Because of the U.S. judicial system has both federal and state courts, it is said to be a dual court system. If you'll notice in this graphic, it shows that nearly every case, whether tried in a federal or a state court, originates in a trial court, the court in which a case is first heard and which determines the facts of a case. The ability of a court to hear a case depends on whether that court has jurisdiction, the authority of a court to hear and decide a case. Federal jurisdiction is strictly defined by Article 3, Section 2 of the Constitution. In this passage, federal courts are empowered to hear only cases involving a federal question or a diversity of citizenship. A federal question is a question of law based on interpretation of the U.S. Constitution, federal laws, or treaties. Diversity of citizenship means that the parties in the case are individuals from different states or that the case involves a U.S. citizen and a foreign government. It may also mean that the suit centers on the complaint of one or more states against another state or states. When a court has original jurisdiction over a case, that court is the first court to hear the case. No other court has yet considered the legal issues in this case. In instances of original jurisdiction, the court must decide what happened in the case and must apply the existing law to resolve the dispute. In contrast, appellate jurisdiction empowers a court to review the decision of the court that has already heard a case. Usually, the appellate court is called upon to decide not what happened, but rather whether the first court correctly applied or interpreted the law. In the federal courts, the federal district courts have original jurisdiction in most cases. The U.S. Courts of Appeals handle first-level appeals of decisions made in those federal district courts. Most cases that reach the Supreme Court come to it under its appellate jurisdiction. The U.S. court system is a dual system in two ways. First, as noted above, parallel federal and state court systems operate largely independently of each other and make law in specific areas. Second, each of these systems has both trial courts and appellate courts. In the brief discussions that follow, we consider the different kinds of courts in the federal system. Federal district courts. The federal judiciary is structured similar to a pyramid. There are 94 federal district courts at the bottom of this pyramid. These are the trial courts in this system, and they do much of the work of the federal judiciary. The function of trial courts is straightforward. Judges or juries decide what happened in a case and then apply the law. For example, in a terrorism case, the judge or the jury assesses whether the defendant is guilty of committing acts of terror as defined by federal law. If the defendant is found guilty, the court then looks to the law to impose a penalty. Federal district courts operate throughout the United States. Every state must have at least one. U.S. Courts of Appeals. At the middle level of the federal judicial pyramid are 13 courts of appeals. As we look at this map, it shows 12 of these courts cover specific regions, plus the federal circuit located in the District of Columbia. The 13th Court of Appeals covers specific kinds of cases involving such matters as international trade, government contracts, and patents. Congress has authorized 179 judgeships for these courts of appeals, though typically there are vacancies. So there are 12. The 12th one is the District Court of the Federal Circuit located in the District of Columbia. And then here are where the other 11 are located. The size of each circuit varies depending on the size of the court's constituency and its caseload. Today, the smallest circuit is the First Circuit. Let's look at that again. Right there. Which consists of 6 judgeships. The largest is the 9th, this one right here, has 28. Each circuit court of appeals is supervised by a chief judge. The chief judge is the individual on the bench who has the most seniority but is under age 65. The judges who hear a case typically include a 3-judge panel made up of the Courts of Appeals judges. They are sometimes joined by visiting judges, usually from the corresponding federal district of the Court of Appeals, and retired judges. In deciding cases, the judges read briefs submitted by lawyers, which argue their clients' cases, and then may hear oral arguments. During this process, no new facts are admitted into evidence. Instead, the Court of Appeals focuses on questions of procedure or the application of law that occurred in a decision of the lower court. The Judiciary Act of 1891 carved out only 9 geographic units for the Courts of Appeals. The increased number of circuit courts to the 13 of the present day occurred through a process by which Congress split up existing circuits. Each new division has typically reflected Congress's desire to keep together states with a similar legal and political cultures. Courts of Appeals have no original jurisdiction. That's an important distinction to make. The AP asks you that a lot. I'll repeat that. Courts of Appeals have no original jurisdiction. That is, these courts do not decide the facts of a case. Rather, as appellate courts, they review the legal procedures of a preceding case and decide whether the law was applied appropriately, given the facts already admitted into evidence. Courts of Appeals are the courts of last resort for most federal cases. Because after a case has been decided by the appellate court, there is no automatic right to an appeal. Although some cases may be appealed to the U.S. Supreme Court, the court ultimately chooses to hear only a fraction of those. Next are special courts. In addition to the federal district courts and the courts of appeals, Congress, acting under Article 1 of the Constitution, created several specialized courts. These include the Court of International Trade, the U.S. Court of Military Appeals, the U.S. Tax Court, and the U.S. Court of Veterans Appeals. In recent years, media coverage has highlighted the activities of another kind of specialized court, the Foreign Intelligence Service Act, or FISA Court. It was established by Congress in a 1978 act that spells out the procedures for the collection of human and electronic intelligence. During the George W. Bush administration, FISA courts were charged with determining whether an individual could be subject to warrantless surveillance of his or her communications. FISA courts are evidence of a notable trend in how the judicial branch is coping with the growing complexity of the types of cases that come before the courts. This trend involves increasing specialization, both by law, as in the creation of special courts such as the FISA courts, and by practice, as when judges develop an informal expertise in a policy area, say DNA testing or software patent law. Legal scholar Lawrence Baum assesses this trend as an effort by the courts to gain and apply the kind of expertise characteristic of the administrative agencies of the government. Whether judicial specialization is established by law or develops in practice, he argues, it reflects an effort to gain the perceived strengths of administrative agencies while retaining the form and name of the courts. The efficiency and expertise that are ascribed to specialization can help courts keep up with their caseloads and perhaps improve the quality of decision-making. Although the specialization may occur in both state and federal courts, it is not possible for the highest court in the land, the U.S. Supreme Court, to limit its expertise. At the top of the federal judicial pyramid sits the U.S. Supreme Court. Although this court has very limited original jurisdiction, which we'll talk about later, it hears appeals from both the federal and the state courts when cases decide their concern a federal constitutional question or when federal law is involved. 9 judges, called justices, sit on the Supreme Court. One of these justices has been specifically selected by the President to serve as the Chief Justice, the judge who provides both organizational and intellectual leadership on the court. The Chief Justice has the same voting power as the other justices, called the Associate Justices, but he or she has an important, distinctive role in the decision-making process. When the Chief Justice argues with the majority, he or she chooses whether to write the majority opinion or to assign it to another justice. The current Chief Justice is John Roberts, whom President George W. Bush appointed in 2005.